Dzień dobry Państwu. Bardzo serdecznie Państwa witam na kolejnym panelu w ramach Igrzysk Wolności. Ja nazywam się Michał Jabłoński, ja reprezentuję tutaj partnerów Okrągłego Stołu Igrzysk, to znaczy Kancelarię Jabłoński-Koźmiński oraz Fundację Instytutu Cicerona. Pozwolę sobie przedstawić naszych gości, więc od mojej tutaj lewej ręki pani profesor Półtorak, sędzia Sądu Unii Europejskiej. Pan profesor Piotr Bogdanowicz, Uniwersytet Warszawski. Pani europosłanka Kamila
Gasiuk-Pihowicz.
Mecenas Katarzyna Kuszko, Kancelaria Jabłoński Koźmiński.
Counsel.
Oraz pan Jakub Bińkowski, członek zarządu Związku Przedsiębiorców i Pracodawców, dyrektor Departamentu Prawa i Legislacji. A także jest z nami zdalnie online pan mecenas Philippe Vlaemminck z Brukseli. Praktyk prawa Unii Europejskiej, osoba mająca na koncie ponad 100 spraw przed Trybunałem Sprawiedliwości i Sądem Unii Europejskiej. Mamy nadzieję, że też będziemy mogli wysłuchać ciekawych komentarzy. Proszę Państwa, temat naszego panelu został zainspirowany tym, że po roku od ostatnich wyborów parlamentarnych, kiedy doszło do tego zwrotu zmiany,
So the change that we had in Poland, it's worth remembering what happened before, the 8-year period.
Okresem takiej dramatycznej
It was the period of a dramatic fight of the Polish state.
Oczywiście ta walka była spowodowana tym, że
organy
unijne
bodies, European organs were defending Polish citizens. They were defending the rule of law. The previous ruling party didn't like
Ale
it.
również pamiętamy z tego okresu, że ci wszyscy, którzy byli przeciwni tym reformom
the so-called reforms of the judicial system back then,
przyjmowali taki dogmat, że w zasadzie
they had this dogma.
Unii Europejskiej jest
Anything from the European Union was good for us.
Spowodowane tym, że właśnie był to taki strategiczny sojusz, który stał na tych wartości.
It was a strategic alliance that protected our values. It's a different situation now.
Czy i w jaki sposób powinniśmy twardo
and whether we should fight for Polish interest in the European Union.
Środki prawne.
Legal measures is one of the means. This is what we want to discuss. What legal capabilities and possibilities are offered by the European Union laws for Poland, Polish citizens in European Union courts? And it goes to Madam Professor.
Dziękuję bardzo.
Thank you very much. A word of introduction.
Przystąpienie Polski do Unii Europejskiej z punktu
Poland's accession to European Union from the legal point of view was a revolution because there is a plethora of new legal measures brought about European laws, starting with Polish courts that need to apply legal instruments and legal laws directly. It's got priority versus Polish laws, and they can issue judicial questions. And there's new actor, European Court.
Tych pytań prejudycjalnych polskie sądy zadawały na początku niewiele, kilka rocznie. Obecnie to już jest kilka.
Polish court asked a few questions. Now it's a few dozens a year.
Pytań prejudycjalnych.
200 questions.
Pytania dotyczące praworządności,
Rule of law, independence of the judicial systems were mainly the questions. So the constitutional crisis increased Polish
chciałabym zwrócić
activity issuing their questions to the Court of Justice of the European Union
dotyczące kredytów
and also credits in Swiss francs. We asked questions to CJEU. This is how we regulated or adopted legal solutions we didn't have before. The second is the European level. New actors, new legal measures. So you can appeal to CJEU, be from citizens, entrepreneurs, or the state of Poland. And there are many cases. Poland is pretty active against European Union regulations, general, like directive bylaws. These pertain to many questions. One thing, when Poland charged the European Commission's decision on Opal pipeline, energy solidarity is what we referred to. That needs to be taken into consideration when issuing decisions on primary energy solutions, and it was accepted in the jurisprudence as the one that should be taken into consideration. Polish citizens charge different decisions to CJEU. One of the cases that needs drawing your attention. There was an individual entity. It was the European Union Court, and CJEU decided that the decisions were never made whether Polish institutions can fulfill their obligations. They are effective, independent. It was about the law of competition. And only then the Commission may refuse to start proceedings in front of the Commission. And another one, the Commission charging Poland. They bring in the legal action. This is the instrument that is difficult to refer to as the one that defends the interest of the state. As the result of these, we pay fines, we taxpayers, the ones imposed by the CJEU. But in practice, 8 years practice showed that the Commission filed in cases against Poland. These were pretty effective. The rule of law infringements were not eliminated, but these were delayed or put at a hold. So we can say that European Commission and the European Union legal system
Dziękuję bardzo.
Act for the benefit of the Polish state. Now I'll switch to English.
I would like to move to Brussels and ask Philippe, what is the most effective way in pursuing national interests in procedures, in lawmaking procedures, but also in procedures before the EU courts?
Thank you, Gail. Good afternoon, ladies and gentlemen. It's a real pleasure of me, being at a distance, to participate in this interesting panel. I think the first thing is that people, when you join the European Union, you need to realize that you enter a framework where indeed, since a long time, the case law has developed, and whereby, I like to refer it's in the way that one of the early judges mentioned it in a book, L'Europe des juges, Europe of the judges. Europe is actually built upon a construction which is unique in the world. But in the meantime, it has developed, it has enlarged, and the legislation of the European Union is affecting all different member states. One has to realize that around 70% of legislation comes from Brussels. And that's an important feature that we need to take into consideration from various angles. It's important from a national angle, and that's where, within the context of the treaty, I believe that national parliaments need to play their role as it is foreseen in the treaty, namely that they can, explore, discuss a proposal that have been made by the European Commission, but also that they can enter into dialogue with the business community to understand very well the way it works. Certain countries have a very specific approach of that. I give one example. In Denmark, before somebody goes to the council, a minister going to the council, he needs actually to discuss the matters in the council with the parliamentary committee in Denmark, which actually creates, added value of the national dialogue. So I believe it's very important that in a very early stage, there is a national dialogue between the business community and between the political community to understand the process as such. Second, I'm indeed a strong believer in the way that the Court of Justice is operating. I think the court is the guarantee for the rule of law, but more than just the rule of law, it is the guarantee for the way that, European law needs to be interpreted, needs to be applied. And there are various examples of that. It provides access both for individuals, it provides access for member states, which are of course privileged actors, being the ones who constructed the treaty. So it is an important factor that the court is there and that the court can guide in a certain way the way that European law needs to be applied. And I think it has been the court from its very origin that created a number of principles that nowadays accepted as normal. The principle of actually the fact that European law is of a level that needs to be applied in all circumstances. There is a lot of member states where there has been discussion with the Constitutional Court, what has a certain prevalence, and I believe that has been sorted out already in various cases. This means we had a recent case, for instance, in Belgium, where in the preliminary ruling the question was, the Constitutional Court did partially put aside national law in violation of European law, but upheld, the past application of it. And the European Court, in its reply, did clearly say that, the national judge needs to put aside the judgment of the Constitutional Court if it does not allow for the full and complete application of European law to the case. So it's very important the way actually that the European Court is an actor in your national judiciary system, because the implications of the rulings of the European Court are really the ones that will help the citizens of your country, will help the business of your country to make sure, that they have this kind of sustainable environment. So, yes, I'm a very strong believer and a very strong, supporter of the European Court, because I believe that all over the Union, it guarantees that we have an application of European law in the same manner.
Thank you. Wracamy do Polski i tutaj pytanie do profesora Bogdanowicza.
Let's return to Poland. Professor Bogdanowicz, the question to you.
Czy twoim zdaniem
in your opinion,
takich wspólnych unijnych wartości,
observance of common European rules, common play field, is it important for the national interests of particular countries? It is very important, although we speak about theoretically two opposed elements, two poles, values. Particular interests of countries where politics seems to be more important than law. Perception in Union of the rules change.
Mało kto pamięta, jak Węgry w 2012 roku
Hungary,
swoją pierwszą, tą tak zwaną reformę,
they introduced the first reform when the Commission instilled procedures against Hungary.
Trybunał Sprawiedliwości brał pod uwagę, w ogóle nie było przepisów dotyczących praworządności.
There were no
nie zwracało się wtedy na kwestie
rule of law regulations. Hungary lost.
Na naruszenie przepisów dyrektywy dotyczącej niedyskryminacji warunków pracy, co nie miało żadnego systemowego znaczenia.
it had no systemic meaning.
Tego roku to się
Starting
zaczęło
2016,
zmieniać. Zaczęło się zmienić dlatego, że
it started changing. European Union discovered that they need to change their attitude to values.
operacjonalizacją
Operationalizing the values is what I called, so that the values have practical significance implication.
szukać
European Union had to find different legal resources
Polskę, żeby
to discipline Poland,
naruszenia
to remove
prawa
legal infringements in European Union regulations. So what's the impact
tę walkę o interesy
on
Unii. Nie ma oczywiście żadnego bezpośredniego
interest, fight about interests in European Union? There is no direct research that shows this direct transition. But we have two things: the power of voices of particular member states in the European Union, and second of all,
pozycja państwa w Unii
the position of a country in the European Union, how it translates to leadership positions, so the most important directors.
Zaczynając od tej drugiej kwestii, czyli
Let me start with the second question. The high-ranking positions.
bardzo świeży
This is a fresh report. European Democracy Consulting of April 2024. It shows a specific trend.
Trzymałem na jako przykładowo wskazanym roku
So I gave you the example of 2023.
22 stanowiska.
In 2023, there were 22 very important positions.
Unii Europejskiej. Sobie wyobraźcie,
And we had new appointments in them. None of these were offered to any representative of CEE. 14,
73% stanowisk,
which accounts for 73%.
16 stanowisk przez przedstawicieli Europy Zachodniej.
Western Europe's representative, 3 for Southern Europe, 3 for Northern Europe. The authors indicated the reasons,
Jeśli chodzi zwłaszcza o Polskę,
especially when it comes to Poland and Hungary.
pędku nieliberalnej
This
demokracji. Po prostu nikt
non-liberal democracy unveiling. Nobody wanted to talk to Poland
wysoko postawionych stanowisk.
and appoint people to these high-ranking positions.
Popatrzmy sobie na drugi
It's got justification. Second of the report, Schuman Foundation's Adenauer's Foundation report of 2020. 3 elements of member states' power. Power of the voice in the European Parliament and Council, reputation of the country, and ability to create coalitions. When we look at Poland, the power of voice in the Parliament and the Council. Poland, 5th biggest country. We have many people there, many representatives. It should translate to the power of this voice. But at the same time, Poland was somewhere in the middle of the ranking, 13th. It was. The reasons? Reputation, rule of law. These were discussed at the General Council of the European Union. There were regular resolutions of the Parliament, which didn't help the climate, and it translated into coalition-building capability. Not to mention about one voting when all other countries were against. Thank you. The question to Euro MP Gasiuk-Pihowicz.
In order to have impact on issues in the EU and take care of the Polish business, can you only analyze it with a strong position in the European Commission when you hold important ministry, or the work in the European Parliament can help you? Obviously it can, but let me address one sentence we have just heard, that nobody wanted to talk to Poland. Let me say that Polish experience shows that Poland under the peace government didn't want to talk to anybody. We wanted to go into conflict. We wanted to use this conflict on our Polish area. And the number of cases we abandoned where Polish interest was not respected is terrifying. There is a lot of things to fight for. 70% of the law applying in Poland is European law. We should care it is good law. I had the commission, I'm deputy head of the internal market and customer protection, and their national interest is not of that great importance. There are some legal laws that acts that such interests might be primary, like legislation for supply chains for military industry, supporting European military companies, where we have clear division between French companies who want to support defense industry companies that can change patents based on which defense equipment is produced, and the Polish interest where we produce mainly based on licenses, so we cannot change the licenses. They come from the US, from Korea, and now the question comes, who's going to get 1.5 billion euros, who can apply for this money from the ADIP, that is the law on military chains? Would it be by companies who can change the patents or those who cannot? There you can see that the national interest is there. You need to take care of it, you need to build coalitions, you need to make agreements. So what the Law and Justice presented, acting for conflict, for emotions, treating compromise as weakness, will never work with the EU. That's a place for something different. Trust, relations, ability to build arrangements. But my commission is special. What we have in common is not the national interest. It's not the political interest. It's caring for consumers, caring for entrepreneurs, for the good existence of the common market. And these interests distribute differently. Look at one of the achievements of the Commission, that is the uniform charger. National interest played no matter here. Neither Poland nor France would push it through individually. Here, you needed to have a different partner for discussion following the so important relations. You needed to build the arrangement of forces differently, and it was possible to unify above parties, above nations, just to take care of the customer's interest and get this uniform charger. Thank you. When we speak of interests, well, we need to ask business people about their opinion. Director Bińkowski, when we think about the Association of Entrepreneurs and Employers, your experience in caring for the interests of Polish business people within the legal procedures, like the legislation in the EU, and how you find yourself when compared to organizations from other countries.
Okej, teraz jesteśmy już na fonii.
Okay, you can hear me now. Well, addressing what we've just heard, we can have this soft power, ability to arrange things, make compromise based on relations. There you have the value issues of critical importance, where getting high positions in the EU structures, that's a deeper problem and historically documented. We've known it for some time that the states from the extension of 2004 are underrepresented in the EU structures, but that's the issue beyond this current conflict on discussion on values. Then an organization like ours focuses on the legislation process, lawmaking. So first I need to mention two things that make on European level more possibilities than in Poland, and then I will address why we do not use it. That's sort of a spoiler. The first two things are permanently related to how far the EU legislation differs from the Polish one. There are two factors. One is time. In Poland, we know that when the project goes for a year, it's extremely long. We believe it's frozen or something of that sort. When you look at the legislation process in the EU, 2-3 years working on a draft plus the implementation period is nothing new. Recently, a deputy minister told me that we should get to the project, to a draft from 10 years ago. Not the concept, the draft itself. So time allows more space for reaction. Then the number of actors with significant voice in the process. In Poland, we have this very strong position of the government, which it's natural due to the systemic organization of the state, which means that an individual MP, regardless of their hard work, has limited impact on the final legislation. On the basis of the EU legislation process, the number of actors worth talking to about the final shape of the legislation, those are numerous, and these talks could be far more effective. If we have so many possibilities, why don't we use those? First, on the national level, we have some problem with linking the dots. So we either value certain solution or we get enraged, but once it's finalized and ready, which we can say a couple of months ago, it was difficult to enter the Twitter without watching some clips on the bottle caps attached. I can't remember the will to discuss that solution that was prepared on the EU level a couple of years before. Only when we have this tangible effect, we react. The same with Green Deal. Everybody's outraged now, but the fact that it was a process of discussion, debate, deliberation, well, it's ignored. So I believe the problem is that Polish structures are unaware, do not understand the specifics of EU legislation, and we are trying to eliminate the gap. We prepare training on the EU decision-making processes for businesses and for public administration. So this is our activity to help the problem. The second problem is, I can see you watching the clock. The second problem, when somebody finally says, I acknowledge it is going to take some time, we need to wait for the effects, but we'll try to get engaged. The second issue is resources. The current Brussels activities require events, expertise, having people there. We have 3 people responsible for our activities in Brussels. And on the basis of numbers, digits, these are exactly the same. The only change is currency. So it's the matter of resources. To that, you should add advocacy for interest, but it's trying, not the guaranteed effect. From the point of view of a company that would be supposed to join this activity, there comes the question of justifiability of spending. And the last point is, I said advocacy for interest, but I didn't use the word lobbying because it has some negative connotations in Poland. It's almost demonic. So we want to lobby for your interests. It sounds bad because everybody believes some bribes, etc. So it's absurd, but it exists in the public space. Moreover, there is some inequality. When I read of relations of here, that the representatives of the academia went to a ministry in Poland or the European Commission, they proposed a solution in their interest, but also good for the public interest, that is presented as a justified social consultation, social dialogue. If a business person does the same thing and present their interest and also refers to the public interest as they see it, then this is lobbying, manipulation by companies. So this is the third issue that we see on our domestic place. We talked about different court procedures, prejudicial procedure also. Kasia, a question goes to you. From your point of view, as a lawyer acting before Polish courts, the prejudicial procedure, is it a potentially useful tool for the defense of the interest of Polish customers that we have, the business people? We know there are more and more of such questions, but the growth mostly refer to the franc loans. Is this procedure used in other areas?
Halo? To jest oczywiście ważne
It is a major question indeed. The prejudicial question procedure is vital. The question, however, is it effective for the Polish court system? For me, this answer is not truly optimistic. It is changing, as we heard from the professor. There are more and more issues. Courts are being more and more courageous to ask those questions, but it's still not spectacular. But the instrument is needed, considering how far the EU law impacts the Polish law. Currently, the Polish law is mostly of the EU origin, so a court dispute is the process of implementing that law, of saying how to understand the law in a particular case. And here the tribunal provides the explanation of the regulation based on those individual questions. And the court system follows the verdicts by the tribunal. The Polish court practice presents skepticism in asking those questions. And when you look at the statistics, according to Statistics Poland, in 2019 we have about 15 million cases in Polish courts. There are lots of us. We like to go to courts, but according to Eurostat's cases, in civil and business cases between 2014 and 22 in Germany or in Italy, there's more populated countries, they had less such cases, but they are countries that ask more prejudicial questions. During our membership, there were 365 questions from Poland. From Poland, there were 1,700. And the number of preliminary ruling questions regards not only the matters vital for businesses, but neo-judges, franc issues that matters for people, but this is some sort of what the tribunal issues from the Polish initiative, where a portion of Polish verdicts occupy some space. There are lots of questions about the tax law. In individual cases, have to apply that law in a given situation.
Jakby widać to potem, że teraz te sprawy będą rozpoznawane już nie przez Trybunał, tylko przez sąd.
These cases shall be reviewed not by the tribunal, but the European Court.
Z drugiej strony mam wrażenie, że jeżeli
On the other hand, I believe that if there is an issue
Trybunale rozsądzona, na przykład
decided by the tribunal, like the frank loans, when we have new questions that are still not responded to, and they regard
lubią się zająć też tym problemem, żeby to pytanie
the explanation of European law, the courts actually do not wish to consider whether they should send such question, and in many business cases the statement of reason is simply copy-paste.
po prostu się pomyli, ale to jest po prostu to samo uzasadnienie i w momencie, kiedy przychodzą nowe sprawy,
when we have still new cases coming in,
pytania nie są właściwie kierowane w mniejszy optymizm.
the questions are not addressed. It's not that optimistic. Professor, you wanted comment, so perhaps you would also move to the second question. I need to ask you how the instruments, from the perspective of a European court judge, how these instruments are used.
Dziękuję.
Thank you very much.
Pytania prejudycjalne do wypowiedzi, pani mecenas, że
in respect of those preliminary ruling questions, the Polish courts are reluctant. We are not reluctant. We are the second in the number of questions regarding taxation, mainly VAT, in spite of the fact that the Germans have more courts and larger population. It's difficult for me to review why it is so, but as a rule, I would see two possible reasons. First of all, in administrative court, the knowledge of the EU law is remarkable, and the belief that the EU law regulates the given issue, and this issue needs to be asked about to the tribunal, and the administrative judges have support in forming those questions. Then the second role is the role of attorneys at court, who pay attention to those complex VAT issues, and they notify the judges about that and request such questions to be sent. And how far it is used, well, you can always improve something. You could complain at the beginnings when we joined the EU. There were a few questions. Well, the EU law and the institutions were unfamiliar to us. The Justice Tribunal was unknown, mixed tribunal of human rights. But in the past 8 years, that has changed. The Justice Tribunal is something that is discussed in mainstream media. The public knows that there is this Court of Justice in Luxembourg, and that is because the civic society acted actively. Courts and lawyers started to use the legal instruments the EU law offers to us. And also some public interests started to grow about Europe, and the Court of Justice, the tribunal, was perceived during this constitutional crisis, was perceived as the last resort when the Polish institutions to protect order failed. And I need to know that the Court of Justice never acts ex officio. They cannot issue any ruling without a question or complaint formed to it. Only thanks to the questions and actions, such
właśnie w zakresie
growth we noted about issues regarding
Trybunał Sprawiedliwości powiedział,
regarding integrity. 60 years ago, the Court of Justice said that the vigilance of individuals is a crucial element to provide efficiency to then community, today union law. And it is so. The vigilance of individuals, of lawyers, of civic society is necessary to keep integrity and the rule of law. And I want to note one more thing.
In the case of Poland and Germany, to this conditionality,
powiedział o tym, że Unia Europejska ma swoją własną tożsamość.
CJEU said that the European Union it's got identity in its legal order. So anytime CJEU defends this identity that is based on European Union values, it also defends constitutional orders of member states because they are common. What we have in Polish constitution is the European Union's value. Thank you. So, EMP.
Czy już po tym stosunkowo krótkim
After this
okresie
short period
działania nowego Parlamentu
of the new European Parliament,
przykłady sukcesu?
do we have any examples of successes defending Polish
Oczywiście półtora miesiąca tak naprawdę.
interest?
To nie jest może taki czas, w którym będzie widać jakieś
1.5
spektakularne
months.
działania z uwagi chociażby na to, że
We don't see spectacular
nowa
outcomes.
legislacja jest, mówiąc wprost, zawieszona.
New legislation seems to be suspended.
Oddechu, czekają
Everybody's drawn in breath.
następnie zgodnie ze swoją agendą, zgodnie ze swoimi priorytetami.
According to our agenda and priorities,
prawne, co do których będziemy ustalali nowe stanowiska. Więc to, co przez ostatnie miesiące możemy uznać za nas
so we can believe to be a success,
wzmocnienie pozycji Polski
is enhancing the position of Poland,
na pewne wzrost także zaufania,
and it translates to bigger trust, ability
sojuszy i wprowadzanie
to
do publicznej
establish some alliances, including
dwie sesje Parlamentu
debates that are
Europejskiego.
important
W
for
poniedziałek zaczyna się
Poland's
kolejna. Mieliśmy tematy takie jak
institutions. We had the debate
debatę dotyczącą
on
wprowadzenia
flood
i przełamania de facto
and the debate on
zasad płynących z Schengen,
breaking the Schengen rules
i wprowadzenia ponownych
by
kontroli
Germany,
na
reintroduction
granicach.
of
Raczej
border
w mojej
control
ocenie z powodów politycznych, aniżeli poprzez wypełnienie wskazań
because of
prawnych.
political reasons
Tak jak
rather than
powiedziałam, przed nami
legal
naprawdę
assumptions.
największa praca, ale nie marnujemy
So we are for the
czasu.
biggest,
Jednym z
most
wyzwań, które
important
mamy w komisji,
work.
to są
One of the
bardzo
challenges in my
wyzwania
commission,
związane z zalewem europejskiego
huge
rynku.
challenges with
Przez produkty
flooding
polskie, które nie
European
spełniają ani
Union's markets
standardów
with
bezpieczeństwa, ani standardów
Chinese products.
środowiskowych.
Neither they meet
Tak
environmental or
naprawdę
safety standards.
ani także standardów bezpieczeństwa danych osobowych.
Personal data standards
użytkowane,
either.
Różnego rodzaju oprogramowanie
They are packed with different spying
pod każdym
software.
względem europejski rynek.
They destroy European market.
To było 2 miliardy
It's a
pasek,
huge
w tym roku
problem.
jest to już
2
4
billion
miliardy pasek.
parcels.
Przypomnę
Now it's
tylko,
4
że
billion
pakiety
parcels.
50 euro są zwolnione z podstawy.
150 euro parcels are exempt from
już w tym momencie na podstawie wszczętych
payments
postępowań
from
szacuje, że około
tariffs.
65%
Olaf
tych
believes
pasek
that
jest
65%.
niedoszacowanych strat.
This is underestimate.
3 miliardy euro.
3 billion euros losses, and the urgency of changes is demonstrated by 2 examples that I quote here. The first, Polish sales platform Allegro, in order to have 20 million clients, they needed 20 years.
Żeby zgromadzić
Temu
15 milionów klientów,
had 15 million clients
agresywnemu marketingowi potrzebowało
owing to
6
strong
miesięcy.
marketing. 6 months
Co my
only.
w tym momencie możemy zrobić?
So what can we
Przerwamy
do?
pracę nad europejskim
We'll be
kodeksem
working
celnym,
on
ale to jest
we'll
niewystarczające.
be working
Musimy
on
tutaj
European
i
Tariffs
wzmacniamy
Codex.
taką presję na to,
So
aby
we
wyłączyć
increase
z
the
tej
pressure
olbrzymiej legislacji te przepisy
to
dotyczące
exclude
50 euro i po prostu
150 euro threshold, to do away with it to introduce tariffs to Chinese products.
Działań to jest właśnie
And the other part of activities, pressure on European Union to act here and now. They have legal basis. We've got extensive European legislation in e-commerce. I could speak at length, at least 10 legal acts that we have. We exercise this pressure.
Toczonych na komisji, organizując także spotkania.
Debates, meetings.
Ale przed nami największe starcie.
And the biggest clash, new commissioners who will be accepted by the Commission, and this pressure will be there. Questions on how they are going to cope with this problem, how fast they will make decisions and instill activities.
Podejmujemy te działania jeszcze na takiej płaszczyźnie, tak jak powiedziałam, relacyjnej debaty, wprowadzania ważnych dla nas tematów do debaty publicznej.
Introduce it in relations, in debates, but we are going to work on hard legislation soon. This will be day-by-day work to create alliances, to negotiate things, rather than fiery presentations that sell well in social media, in Chinese TikTok.
I want again to ask Philippe, what do you recommend for Poland, for Polish politicians, Polish business, in context of pursuing national interests in EU?
Okay, well, thank you, Michael. Let me say this debate is very interesting, especially the most recent statements about also what happens outside the EU, and that's indeed part of the way that we need to address the problems. I see, I would say, 3 levels. First of all, the level of the member state as such. Some of the speakers, they talk about, reputation and trust. I think this indeed are 2 extremely important elements, but I would like to add to that awareness and knowledge. I think it is very important that the member state does show in the various institutions, that they contribute, that they are interested in contributing. I can tell you, participating in preliminary rulings as a member state is of quite adamant importance. Not only in the rulings that are addressing questions coming from your own state, but in certain policy areas where, as a member state, you also want to make sure that the European Court does hear your voice. And participating on a very regular basis as a member state in various preliminary rulings is an issue that is very relevant, because it creates indeed this kind of, confidence that you're in a certain area as a member state, having a lot of expertise, and that you want to share that with the Union. I have been representing the Belgian government in around 60 cases, which were not cases coming from Belgium, but actually cases about certain areas of law where we had certain expertise, and where the court at a certain moment of time did understand that some of the member states can add value to the preliminary ruling. So I believe that a member state needs to play also a role in the Court of Justice as such, not only in its own cases. That adds to, I would say, the reputation. The second element of reputation is indeed the way that the member state does act during its own presidency. A presidency is, in my view, an enormous opportunity, to show that you can indeed build compromises, that you can work on solutions for the Union. Indeed, for various of the solutions are a very long-term approach. Legislation in Europe is the Commission has patience, and they will take all the time necessary to come to the solution. But a presidency is a key element in that. And I believe that, the way that you show during the presidency, the way that you contribute to the construction of the Union is also going to add to the reputation and the trust that they have in you. And I believe that will actually then turn into all those kind of issues about how many people of your country will be nominated in very crucial posts. That's the first level. The second level is indeed the way that the business community does act. We did 6 years ago a study for the Polish Employers Association, a comparison with what other member states were doing. And what we could see is that the German BDI and the Italian Confindustria were really at that moment the leaders in Brussels. They have a very large number of people being there. They participate in a lot of debates, and our advice at that time was that Polish industry associations must switch from the role of recipient of European law to the role of co-author of European legislation by proactively monitoring the developments, by engaging in advocacy. And I don't consider lobbying as something wrong. On the contrary, in Brussels, for the institutions, it's very important that they understand, that they can listen, that they can hear your concerns, that they understand your needs. That's actually the way that Europe works. So I believe it is extremely important that as Polish business entity, you participate, of course, to the overall, like Business Europe, to the Social and Economic Committee, yes, but also you need to have a very strong presence in Brussels, whereby you can actually be the advocate of the interest of your business community in your own country. And that requires also that you enter into dialogue in your capital, but also in the dialogue with your permanent representation in Brussels. So I believe it's a very crucial element that the business community participate in the legislative process, but also that the business community uses the instruments available to them. There are various instruments available under union law where the business can react. We were just talking about, the impact of China. Well, there's the trade barriers instrument. There is the foreign direct investment regulation. All of that are instruments that one can use. You can address points of interest with regarding to trade issues, so that actually the Commission, the DG Trade, can take it up and can discuss the matter externally also at the World Trade Organization. I believe, also being involved internationally, not only inside the EU, but also internationally, understanding the importance of the trade barriers questions, understanding the importance also of what happens in Geneva with the World Trade Organization is very important as a business community. So the business community has a second very important role as an actor. The third one that I believe is very relevant as well is what I call the broader context of education. Education at all levels. I did participate 2 years ago at a big conference in Paris organized by the French delegation of bars, where they were actually a whole day with judges, with other people, discussing the value and the way that one could enhance the use of preliminary ruling cases. Teaching it, making sure that lawyers understand the value of it in various areas, that also judges, national judges understand it, that, by using the preliminary ruling, they can improve the way that judgments are rendered in their own country. And in that regard, I also like very much to advocate for, bringing much more students on board. I'm a very big fan of the European Law Moot Court competition that brings students of various member states together. I believe this is also an area we need to make sure that all the actors in the judicial system, national judges, lawyers, students, all have a very clear understanding of the value that, using European instruments in court, but also the instruments that are available under administrative rules at the European Commission level, that they can be used to the national interest. So that is, in my view, the three elements. If you want to defend properly the Polish interest, make sure that government, business and education all play together a very important role.
Thank you very much. Philippe. Chciałem zapytać po raz kolejny pana dyrektora Bińkowskiego w takim razie, czy jako biznes, jako przedstawiciele biznesu jesteście państwo
representatives of business,
współpracy z naszym polskim
I'm happy
rządem
with collaboration with
do walki o polski
government fighting for Polish interest in the European Union?
Tak. Ja myślę, że w takim szerokim obrazku tak. Dwie rzeczy, na które bym
two things that I'd like to pay attention to.
I tutaj tak jakby bym też rozdzielił trochę. Jedna rzecz to jest
separating these two things. We collaborate with the government when working out Polish positions to legislative proposals. So what I would like to see, what I request is to make this consulting process more structured. It depends on the ministry and the mode of consulting, parameters.
2 dni czy 30
2 days or 30 days
stanowiska.
to refer to a specific position It is very important from our point of view, and we've got Polish EMPs that we collaborate with.
Standardowo jest to rozkład Gaussa, nie? To znaczy
This is
jakaś
Gaussian
wąska
distribution.
grupa, która jest
A narrow
całkowicie
group
nieresponsywna, jest
that is
wąska grupa, która
irresponsive,
jest hiperresponsywna.
hyper-responsive,
Nie,
also
jest
narrow,
środkowy, największy, najszerszy
and
przedział,
the mid-section,
czasem się uda wejść w dialog,
people
czasem
that you can
nie. Ja
dialogue
myślę, że
with,
tutaj,
sometimes not.
Dlaczego z kolei my byśmy chcieli to przejścia na takie
We would like to
defaultowe
see
nastawienie,
a
bardzo otwarte
default
na dialog z biznesem, bo
attitude
paradoksalnie
open
czy
for
nie,
dialogue with
tak naprawdę w
business.
sprawach, które z
Be
naszego
it a
punktu widzenia są
paradox or
ważne,
not.
często z polską delegacją, niezależnie od grupy politycznej, mamy bardzo podobne
We
stanowiska, bo to
have
jest kwestia
similar
zdiagnozowania
positions with the
racji
Polish
stanu
delegation because this
europejskich.
is
Tutaj często
recently
mamy
a out
bardzo
of
zbieżne
Poland and Europe,
podejście, więc
regardless the ruling
to takie
party.
dwie rekomendacje,
Positions
bo
are pretty
widzę
similar. These are my
niepokojąco
recommendations.
kończący się czas.
I can see the time is shrinking.
Dziękuję bardzo.
Thank you very much.
W takim razie jeszcze może króciutko
Briefly,
pytanie do mecenas Kuszko.
Ms. Kuszko, the attorney of laws.
Czy właśnie, jeżeli chodzi o twoje obserwacje,
Speaking about your observations,
czy polski rząd,
Polish government and parliament,
korzystają z tych
do they
instrumentów
sufficiently
prawnych
use
sądowych,
legal
tak,
instruments,
jeżeli chodzi o
in-court
obronę,
instruments,
na przykład interesów polskiego
when
biznesu?
defending interests of Polish business?
Problem z punktu widzenia biznesmena czy biznesu.
Business person's point of view and citizens' point of view.
Inicjatywie państwa.
You need to rely on the state's initiative.
Tutaj w systemie, jak wiemy, właściwie będzie się sprowadzało do parlamentu, czy właściwie
It all boils down to parliament, government.
Pomimo tego, że Trybunał jest w stanie
Although
rozstrzygać o zgodności z prawem aktu prawa wspólnego, w tym dyrektyw,
EU
rozporządzeń, co
can
ma
decide about
znaczący wpływ na działanie przedsiębiorców.
compliance with acts,
Tutaj są
which
oni całkowicie
impacts
niezależni od
entrepreneurs' activity, but they depend on the government's initiatives totally.
Nasze państwo nie jest specjalnie, tak jak
Our state,
mnóstwo wskazał,
as the first speaker said,
nastawione na w jakiś sposób taki zinstytucjonalizowany
is not
na pozyskiwanie jakby zdania
a
przedsiębiorców,
proponent
które,
of
na przykład
asking
w tym znaczy prawa, które zostało
questions
wprowadzone, a
among entrepreneurs
wątpliwości co do tego, czy jest
by the virtue of its
zgodne z porządkiem
institution.
prawnym unijnym.
Whenever they
Na to,
request
żeby
compliance
takie
with European orders, they are not ready to listen to entrepreneurs.
procedur. Teraz w
We don't have
regulaminie Sejmu
procedures.
zostały w 2011 roku
In 2018,
wprowadzone reguły,
rules
że
were
komisja
introduced
lub
that the
grupa
Commission,
posłów może
the group of 15
złożyć
EMPs,
projekt uchwały
may
wniesienia do Trybunału
file
Sprawiedliwości skargi w sprawie naruszenia
bill
przez akt ustawodawczy unijny zasady pomocy
when there is
i
a kind of infringement.
nadane w
I was looking at the data from January.
jeszcze ani razu. Natomiast
It's never happened until now.
tak, regulamin Sejmu teraz przewiduje też to,
The
że
Sejm's
ta grupa 15
bylaws
posłów,
informs that a group of 15 MPs or the Commission or the committee from Polish Parliament may also decide to consult whether European Union law that will be introduced, should we file any remarks.
I wydaje się zasadne, tak jak właściwie
It seems justified, as the first speaker
wydaje
said,
się zasadne, żeby stworzyć jakiś punkt kontaktu
we
pomiędzy
should create a kind of
rządem
contact
a
point between the
przedsiębiorcami,
government
żeby to,
and enterprises.
też abstrahując od tego, jak jest postrzegany lobbying
Regardless how you perceive lobbying
społecznej, się
in
kojarzy
social
z
opinion, because lobbying is associated with
to
corruption,
przedsiębiorca będzie wiedział,
when
jak
the
prawo
interpreter really
unijne,
knows
które na przykład
how
zostało
European
wprowadzone lub
Union law
wpływa na
that
jego biznes,
is
to niekoniecznie
implemented
musi
or
wiedzieć
is
o tym,
designed impacts their business.
posłanka, niezależnie od najlepszych intencji.
EMP may not know
Dziękuję
that,
bardzo. To jeszcze
despite of the best
finalnie, bo
intentions.
faktycznie czas nam już się kończy. Finalnie pytanie
We are running
do
out of
profesora
time.
Bogdanowicza.
Profesor
W zasadzie
Bogdanowicz.
częściowo było odpowiadane, ale może jeszcze coś będzie
It
chciał
has been
dodania
partially
w
answered.
sprawie właśnie tego, w czym najlepiej tą siłę polskiego głosu
Polish
widać,
voice
jak
power.
to oceniasz.
What do you see best?
Moja teza jest taka, że ją
My take on
zdecydowanie
it
za
is
słabo.
rarely do we see it.
Odnoszę
It's
się do tego, co pan
insufficient.
dyrektor powiedział.
Referring to what
Ja nie
director
twierdzę,
said,
że,
I'm not saying
za tą małą
that
liczbę stanowisk
the small number of high-ranking positions held by Poles is attributed to infringement of the rule of law or the conflict, but it didn't help.
Jesteśmy piątym największym państwem,
We are
od
fifth
20 lat w Unii Europejskiej.
biggest country in European Union. We've been there for 20 years,
Państwem, którego nie można porównać z tymi innymi mniejszymi
and we
państwami
cannot be
Europy,
compared with the smaller ones in CE.
Rzeczywiście państwa Europy Środkowo-Wschodniej, w tym
And
Polska,
CE countries,
są
Poland,
niedoreprezentowane,
are
natomiast
underrepresented,
jest taki, że
but there is a
państwa
trend.
Europy Zachodniej,
Western Europe countries,
także państwa Europy Południowej, czy
Southern Europe countries or Northern Europe countries have even greater number of positions, and it should be opposite direction.
bardziej pesymistycznie niż optymistycznie, ale
More
wiedzmy, że to się
pessimistic rather than optimistic. I hope it will change.
Kropka nad i. Chcę
I need to dot I's. On the 9th of October, Agnieszka Walter-Drop will take the position of the General Director for Structural Policies and Cohesion. This is the highest ranking Pole in these structures. One more thing. I heard it from one of the European Association members who want Polish employees in institutions to be high-ranking. He mentioned the first meeting with politicians of law and justice.
I na dzień dobry właśnie spotkali się dokładnie te emocje, o których
They
pan
met
profesor Bogdanowicz.
the emotions that Professor Bogdanowicz was saying apply for representation of Polish employees in institutions, and they heard that there are traitors who run away to get money to Brussels. So this attitude of Polish government made it difficult to support Polish employees. But as you can see, Agnieszka Walter-Drop, women make me proud.
Dziękuję bardzo.
Table stand. Thank you very much.
Jesteśmy po czasie, więc
Time's
bardzo
up.
Państwu dziękuję
Thank you very
za
much
ciekawą dyskusję.
for interesting discussion.
Liczymy rzeczywiście na to, że
And we hope
w niedalekiej przyszłości te niektóre
that soon
pesymistyczne
these pessimistic
aspekty się
aspects
zmienią i
will
będziemy
change
mogli spotkać się zupełnie
and
innych
will be meeting
okolicznościach.
in different realities. Thank you.
Jedzą kanapki z kawiorem.
Nadzwyczajna kasa.
Obrażanie dziennikarz telewizji polskiej.
Chodzi o działania polityczne.
Ratowanie ofiar dla pedofilów.
Für Deutschland.
TVP Info. Włącz się na nowo.
Radość, nadzieja, życie, wyzwanie, pasja, pamięć, zaufanie, pokój, jedność. Słowa tworzą świat. Polskie Radio. Źródło wiarygodnych informacji.
Plany biznesowe powstają z marzeń. Dlatego nie ma dwóch takich samych firm. Jedni chcą działać na całym świecie. Innym cały świat mieści się w dłoni. Sukces biznesu to nie tylko jego wielkość, ale też szczęście, jakie przynosi ludziom. PKO Bank Polski.
Uwielbiam szycie w sieci. Wczoraj podszyłem się pod wnuczka, wieczorem uszyłem intrygę na apce randkowej, a dziś planuję grubymi nićmi szyte oszustwo z promocją. Tak się szyje.
Na oszustów są sposoby. Zapoznaj się z poradami ekspertów na niedajsiepodszyć.pl.
It's not always easy to recognize. It may look like this, or like this. It may be a burden, but it is a responsibility that we embrace nonetheless. But if it means this for one person and this for someone else, maybe it ultimately means being there for one another. It isn't handed to us, but we know where to find it. And how it feels, how it tastes, and what it sounds like when we finally have it. It means different things to different people, but for many, it means everything. And if we all fight for it, it that will eventually bring us together.
Polskie Radio.
Jedynka.
Rodzina spółek Pelion to 12 000 osób pracujących w ponad 300 spółkach w Polsce, Szwecji, Wielkiej Brytanii i na Litwie. Jesteśmy liderem w branży ochrony zdrowia. Od 1990 roku dbamy o długość i jakość życia. Pracować z nami możesz w jednym z 7 obszarów.
Zapraszamy do Trójki. Od nowa.
Trójka. Program Trzeci Polskiego Radia.
Czy wytrzymasz klockowe tortury ze stoickim spokojem? Czy w twardych negocjacjach zachowasz zimną krew? Czy poddasz się dobrowolnej eksmisji ze swojego łóżka? Brawo! Test na obecność serca zaliczony. To znaczy, że ty też możesz być rodzicem zastępczym. Dowiedz się jak na testserca.pl.